All right then. Good afternoon, everyone. Today is September 26th, 2020. This is a special meeting of the members of the State Liquor Authority. Present, being conducted in Albany and also remotely. Present today by telephone is Chairman Bradley.
Yes, I'm here.
We also have by video, as can be seen by those viewing, Commissioners Ford and Commissioners Fan. Staff in attendance, we have General Counsel Meyerhoff on video. We have Deputy Commissioner Licensing Roberts on the phone.
I'm here, thanks.
And myself, Secretary Donahue in the Albany offices. We have 5 items on today's calendar, all related to summary suspension orders. With that, I'm going to call the first item, which is 1253 MM. Duchess OP 222-1737. It's Roccos Bar and Grill LLC.
Good morning, Jamie Gallagher appearing on behalf of the authority. This premises was licensed on August 27th of 2020, so just recently, as a restaurant serving beer, wine, cider, and liquor in Dutchess County in Fishkill, New York. The method of operation includes live music, but not dancing. On September 25th, 3 investigators from the Liquor Authority arrived at the premises, and they found a band playing under a tent with 50 patrons present. Now, the issue is at least 30 of them during the course of the investigators' visit, and they were there for just under an hour. At least 30 of them were walking and standing without masks on at any given time during the visit. 8 to 15 people were observed standing and consuming beverages at any given point. And at any given time during the visit, there were approximately 10 people standing and dancing. At one licensed point of sale, the bartender was improperly wearing his face covering. The investigators attempted an alcoholic beverage purchase, and they were not required to buy food with the alcoholic beverage. At the other licensed point of sale located outside, 3 bartenders were observed without face coverings. I also looked at the photos, and there's several photographs of patrons standing and mingling, congregating, and consuming beverages while standing at this point of sale. This premises has no history. I mean, they've only been licensed for a few weeks, but they had been previously warned by Beverage Control Investigator Benedetto on September 17th of 2020 because of complaints that were received about social distancing. So the investigator advised that there was a restriction relating to dancing. At the time that he was there on September 17th, he didn't observe any violations. Doesn't indicate that there was any event happening at that time, as no patrons were present during Investigator Benedetto's visit. But in any event, despite that warning, were observed during the visit of September 25th. This premises is being charged with a violation of Executive Order 20238, 20243, 20216, 20252, and failure to supervise. I've attached 13 photographs as well as the report of investigation from the visit of September 25th and the report from Investigator Benedetto's warning. This premises is operating as a bar and a concert venue during a period of time where this types of operations are impermissible. They applied as a restaurant. It doesn't appear that they're operating as a restaurant. They're selling alcohol without food, and although they're approved for live music, this was clearly a concert that was going on, which is not permissible at this time. Based on what the investigators observed, with the lack of social distancing, lack of face masks being worn, the dancing, the congregating, the mingling, this premises is an immediate health danger to the health, welfare, and safety of the patrons of the establishment and the general public at large, and Counsel's office is requesting an immediate summary order of suspension in this matter.
All right, with that, Commissioner Fan, do you have any questions?
No, I have no questions. Thank you, Jamie.
Commissioner Ford, do you have any questions?
You said this place is located on a golf course. It's not part of the golf course, is it? You know?
I don't know because the entire licensing file wasn't actually scanned yet. This premises is so recently licensed. I'm going to have somebody find it on Monday,
Okay.
scan it all in so I can, run through it and look.
Okay.
I can look at I have the digest sheet. They licensed the deck, patio, yard, a freestanding building. They're licensing the ground floor of that building. And so their maximum occupancy is 85. If that
Okay.
helps.
Thank you, Jamie.
Yes.
Chairman
No further-
Bradley, oh, sorry.
No further questions.
Chairman Bradley, any questions?
No, I don't have any questions.
All right, with that, I'll call for your votes. First, Commissioner Fan.
Based on the evidence presented by Counsel Gallagher, it's clear that this location is an imminent threat to public health, safety, and welfare, and I vote to summarily suspend this license.
Commissioner Ford.
Based on evidence presented by counsel, I will vote to summarily suspend as well.
Chairman Bradley.
Based on the evidence presented by counsel, I vote to summarily suspend.
All right, the next item, 1253 NN, Suffolk OP 1142670. Licensee is Roccos Catering LLC.
Good afternoon, Stephen Armstrong on behalf of the Counsel's Office in support of the summary suspension of this license located at 100 Fox Hill Drive in Calverton, Suffolk County. This is an OP license. The method of operation is as a restaurant/catering hall. License was first issued in September of 2003. As the executive order violations here, yesterday, September 25th at approximately 7:10 p.m., Task Force Investigators McGee and Gallion conducted a visit to the premises at the request of the lead desk. I spoke to Investigator McGee this morning. Upon arriving, the investigators were met by an individual named George Regini, who is one of the licensee principals. He stated there were 75 guests present for a wedding reception. However, the investigators counted at least 95 guests at the premises, and that's in addition to staff. Investigator McGee thought there were approximately 15 staff present. Investigators took photographs which substantiate the written observations. Approximately half of these 95 patrons were observed inside the premises. Many of them seated at tables, but there were also high-top tables with patrons standing around them. Many of the patrons indoors were not wearing masks, including many of those who were observed standing. The remaining patrons were observed outside, either on a deck or in a patio area surrounding a fountain in the rear of the premises. As you can see from the photos, these patrons are congregating together, socializing, while not wearing masks or social distancing. You can also see in the photos that many of these patrons, at least the ones on the deck area, are holding glasses or open containers of alcohol. Mr. Regini stated that he thought he was operating in compliance with the executive orders. He didn't offer any excuse beyond that. However, Executive Order 202.45 and the SLA guidance are very clear about the limits on the size of gatherings. The SLA guidance has a specific section that addresses weddings and other similar events. It states in the relevant part that gatherings are limited to parties that are the lesser of 50% of the maximum occupancy or 50 or fewer people, and that's at least in Phase 4 regions. So that's a hard limit on party size of 50 people. The executive orders also require that the licensee comply with SLA Department of Health guidance on indoor food service. That means guests must be seated, proper spacing, use of facial coverings, and so on. And the licensee was operating in clear violation of those rules. You had numerous patrons standing, congregating, consuming alcohol in outdoor areas that are not part of the licensed premises, which is a clear violation of Executive Orders 202.38 and 202.43. And based on this record, I ask the members vote to summarily suspend this license pursuant to Section 413 of the State Administrative Procedure Act. Thank you.
Tom, it's Gary Meyerhoff here. I just wanted to point out, if we had the Twin Pounds case on first, it would have been obvious. But we have a case on later today in which a similar sized wedding reception took place. And we had 50 COVID positive tests, and we're contact tracing because another 81 people have been contacted. These are super spreader events that are a grave risk to public health, safety, and welfare. And this is just happen to have today one where we see the results of these types of events, and one where we see the risks. With that, I turn it back over to you, Tom.
I'm just going to ask everybody to pause for a second. I think we lost the live feed just a moment ago, so just hold on for a second while I get that back. All right, so I don't think we lost the feed. I think I just lost it on my computer for a second, so I apologize. All right, so with that, Commissioner Fan, do you have any questions?
No, I do not have any questions. Thank you, Council Armstrong.
Commissioner Ford, any questions?
No, I don't have any questions.
Chairman Bradley, any questions?
No, I have no questions.
All right, with that, I'm going to call for the vote of the members. First, Commissioner Fan.
Based on the evidence presented, I find that this location is imminent threat to public health, safety, and welfare, and I vote to summarily suspend this license.
Commissioner Ford.
I will vote to summarily suspend as well, based on reasons presented by council.
And Chairman Bradley.
Based on the evidence presented by counsel, I'm going to vote to summarily suspend.
All right, then the next item I have is 125300. It's Nassau OP 1312023. The licensee is Vintage Bar Lounge LLC.
It's Stephen Armstrong again on behalf of Council's Office, support of the summary suspension of this licensee doing business as Vintage Sports Bar located at 3037 Merrick Road in Wantagh. This is an OP license. The method of operation is as a restaurant. A license was first issued December 28, 2018. The maximum, or their certificate of occupancy lists the maximum capacity at 79. As to executive order violations, this licensee is a repeat offender. The most recent incident occurred this morning, September 26th at approximately 2:30 a.m. Officers from the Nassau County Police Department conducted an inspection of the licensed premises. Upon entering, officers found the location to clearly be overcrowded. They counted a total of 98 people inside the location, which is well over the maximum occupancy. As the photos taken by the officers show, there were numerous patrons standing, congregating close together. Very few can be seen wearing masks. And I think it's obvious from the photos that the premises is overcrowded to the point where social distancing is not possible. Officers also observed several patrons dancing to music. It also appeared as though patrons had been playing pool at the time the officers arrived. There were also at least 2 staff members observed and photographed without proper facial coverings. The licensee principal, Michael Perenio, was present at the time of the inspection and was issued several summonses by the officers. As I said, this is not the licensee's first offense. There have been 2 prior notices of pleading issued covering 3 dates in July where violations of Executive Orders 202.16 and 202.38 were observed for things like staff not complying with mask requirements and social distancing between patrons not being enforced. Mr. Perenio, again, who's the licensee principal, was present during at least 2 of these dates where the EO violations were observed. All of these prior visits were disclosed. 2 were from the Nassau Police Department. The third was SLA investigators. Executive Order 202.45 and the SLA guidance set very clear limits on the size of gatherings. The SLA guidance states that gatherings are limited to parties that are the lesser of 50% of the maximum occupancy or 50 or fewer people. It also requires that the licensee comply with SLA and Department of Health guidance on indoor food service, seated guests, proper spacing, face coverings. for the licensee to allow the premises not just to exceed the 50% capacity limit, but to exceed its maximum occupancy under these circumstances is truly egregious. And based on this record, I ask that the members vote to summarily suspend this license pursuant to Section 413 of the State Administrative Procedure Act. Thank you.
All right, with that, Commissioner Fan, do you have any questions?
Do they have any adverse history?
So they had a prior, I believe it's a failure to supervise case that's pre-pandemic, but nothing sustained at this point.
Okay.
Commissioner Ford, any questions?
Yeah, Stefan, what you said they were licensed in 2018, is that correct?
Yeah, December 28th, 2018.
Thank you.
All right, then, Chairman Bradley, do you have any questions?
I have no question.
All right, with that, I'll call for the vote of the members. First, Commissioner Fan.
Based on the evidence presented, this location is an imminent threat to public health, safety, and welfare, and I vote to summarily suspend this license.
Commissioner Ford.
I vote to summarily suspend for the same reasons as presented by counsel.
And Chairman Bradley.
Based on the evidence presented, I vote to suspend.
All right, then, the next item I have is 1253 PP. It's Oneida SL 2504150. The licensee is Twin Ponds Golf Association, Inc.
Good afternoon, Chairman, Commissioners. Senior Attorney Caraminal here on behalf of Counsel's Office on this request for emergency summary order suspension of Twin Ponds Golf Association, Inc. Original license issue date here is at least the year 2000, possibly, according to the file, as early as 1989. It's just not scanned in that far back. Let's see, Saturday, September 12th, investigator Bart Gottsman with the authorities Enforcement Bureau received an email complaint from the Oneida County Department of Health relative to executive order violations occurring at the licensed premises relating to a wedding that took place at the licensed premises on August 29th. Monday, September 14th, investigator Caitlin Tucker contacted Daniel Gilmore with Oneida County DOH. She didn't receive a reply email on the 15th with the DOH inspection report. That inspection report is where the August 29th wedding date came from. Apparently, the DOH on September 9th interviewed the principal at the licensed premises, David Germond, who admitted hosting the wedding on August 29th, 2020 that featured 108 guests in the ballroom at the premises, which would violate authority and DOH guidance on the maximum gathering of 50 persons or more. Apparently, the wedding ceremony itself was held in a different room at the premises. That room has a maximum occupancy of 80 persons, which would obviously put this over the 50% maximum capacity guidance from the authorities as well as DOH. According to DOH, patrons were not required to wear face masks at the event. Were regularly traversing throughout the event without face masks. No effort was made to prevent two-way foot traffic in shared spaces at the premises. No efforts are made to enforce minimum 6-foot spacing in shared portions of the premises, such as hallways or bathrooms. There were no COVID-19 precautionary signs posted at the premises. No hand sanitizer was made available in high-touch areas, such as outside of the bathrooms. There was no effort made, apparently, to close off, clean, or disinfect areas that had been inhabited by a person confirmed to have COVID-19. Employees at the licensed premises were not screened for symptoms daily. There were no procedures for that. Employees did not affirm they had read and then understood the New York State issued guidance on COVID-19. There had been no contract tracing log kept at the licensed premises in accordance with DOH guidance. Finally, the email included an attachment that listed 50 cases of COVID-19 and 161 contacts and counting that Oneida County DOH had traced back to the August 29th wedding at the licensed premises thus far. Of note, this is not the first contact we have had with this licensee during the pandemic, or the reopening of the pandemic. On July 22nd, 2020, Investigator Meyer with SLA Enforcement telephoned David Germond regarding a community complaint we had received relative to another wedding that occurred in July where there was apparently hundreds of people on the premises. During that July 22nd phone call, David Germond was made aware of the community complaint by Investigator Meyer, as well as the requirements under the executive orders, in order to operate in compliance. The licensee will be charged with violating Executive Order 202.45 and related authority and DOH guidance for these violations. The need to ensure social distancing for patrons of licensed premises, as well as their use of facial coverings, is essential to the governor's executive orders, and it's been widely reported via media sources. The Office of Counsel believes it's simply not reasonable that any licensee could be unaware, any retail licensee could be unaware of their responsibilities to operate in compliance with the governor's executive orders during the pandemic. In fact, in this case, this licensee had actual notice. He had a phone call from us already relative to a community complaint of another wedding at the premises, another large wedding at the premises. So as a result, it's a position of the Office of Counsel is this licensee cannot be trusted to operate safe licensed premises during a pandemic in compliance with the governor's executive orders. According to the information we received from the Department of Health, this licensee chose to operate on August 29th, again, as though there was no public health crisis in effect currently. Due to the foregoing, the Office of Counsel hereby requests an immediate summary order of suspension for this premises. Thank you for your time.
All right, with that, Commissioner Fan, do you have any questions?
Paul, is there an upcoming event?
We have a complaint that there is tickets being sold on the internet for a DJ event at this licensed premises. I didn't have any further information other than the complaint, so I didn't want to. I don't want to bring that to your attention at this point. But we do have a complaint about it.
Okay.
I'm sorry, I was just going to add to that. I actually was wondering why the DOH had not closed this place. But apparently it has not. So they're still capable of operating, and that's why we're here to address the liquor license situation.
And what is the proposed date of the DJ event?
There wasn't any information about the event itself, so I didn't have anything to fill that out, or I would have included it in my presentation.
Okay.
All right, with that, Commissioner Ford, do you have any questions?
I do, but it's really for counsel. And I hate to do this to everybody, but could I have a moment with counsel?
Sure.
All right, so we'll take a brief recess of the meeting. Just ask you all to mute your lines, and then when we get done, we'll go back live, so to speak.
Commissioner Ford, you're going to call my cell phone? Thank you.
All right, we are back with the meeting after a brief recess for a conference with the council. Commissioner Ford, any other questions?
I was going to say that after a brief consultation with Commissioner Ford, he's going to recuse himself from ruling on this matter based on some prior personal contact with this licensee.
All right, then, Chairman Bradley, any questions?
I have no question.
All right, with that, I'll call for the vote then. The full board, first Commissioner Fan.
Based on the evidence presented by council, I find that there is imminent threat at this location, imminent threat to public health, safety, and welfare, and I vote to summarily suspend this license.
Chairman Bradley.
I don't think that there has been a clearer case of a risk to public health, safety, and welfare since we've been doing these summaries. It appears a third of the guests, am I wrong in that, have contracted COVID?
Closer to half, sir.
Half. So I vote to summarily suspend based on the evidence that's presented.
All right, then the next item I have is 1253 QQ. It's New York OP 1024379. The licensee is the Cloister East, Inc.
Good afternoon, members. Gary Meyerhoff, counsel to the authority. As you know, on August 7th, 2020, we presented this case to the full board. We had an investigative report and some sheriff reports about inside service, lack of social distancing, patrons congregating in front of the premises, and a number of other fire, safety, and related violations. And based on that evidence, the board entered an order of summary suspension on the 7th. We've since learned in this case that the corporation that holds this license has been dissolved since the 1990s and has been falsely reporting its lack of changed circumstances in renewal application after renewal application. In any event, ordinarily a licensee in this position would either plead not guilty and ask for a hearing to respond to the charges or engage in negotiations to try to settle them and move forward. This licensee did neither. Instead, this licensee waited for a period of days, and then we learned that they were going to file a lawsuit from the press. They did file that lawsuit, and one of the things they curiously argue in the lawsuit is that they've been denied due process because they could not get a hearing, even though they never asked for one. As you know, the summary suspension process is not itself discipline. It's there to protect the public health, safety, and welfare while the disciplinary process goes forward. The discipline comes after the hearing at which the charges are sustained. If the charges aren't sustained, I suppose there wouldn't be any discipline. So we've been litigating with this licensee for several weeks, and they never asked for a hearing. The current status, though, is that in the most recent round of litigation, a state court judge entered a temporary order rescinding the suspension and requiring us to return the license. That was on around September 10th. That order did not give any grounds, did not say that there was anything particularly improper with the evidence or the reasons for the charges, just allowed the licensee to have the license back until a hearing could take place sometime in October. For that reason, my office decided that we needed to pursue the hearing. So right now that hearing is scheduled to begin on October 6th. We noticed the hearing because the licensee never requested one. And actually the licensee recently asked for an adjournment of that hearing. We scheduled it for September 28th and they've asked for an adjournment. It's now set to begin on October 6th. Under the circumstances, with the hearing about to begin, the time and resources spent on this case will soon be over as it reaches the disciplinary phase. And if the charges are sustained, discipline will be awarded. The suspension order, which has already been temporarily rescinded by a judge, is, in my view, collateral at this stage. even though it was proper when it was entered. To avoid further litigation burden, we ask that the order be vacated. This is in no way going to impact our effort to prosecute this case. It's just a question of resources at this point, and my office is focused on prosecuting the case and moving towards a prompt conclusion. For those reasons, we ask that the board enter an order vacating the suspension order.
Commissioner Fan, any questions?
Gary, explain to me, so if the order has already been rescinded by a judge and they currently have the license, right? So then, isn't it already rescinded because of the court?
It's a temporary order. There's further litigation. There's an Article 78 proceeding, which we could continue to fight.
I understand. Okay.
And in my view, that's a collateral matter that is a waste of the agency's resources, and better to just move forward with the hearing and avoid the need for further litigation over an order that's collateral at this point.
Okay. I don't have any other questions.
Commissioner Ford.
So Gary, they can go back to selling today. Is that correct if we lift this?
They have been.
They've been open for a couple weeks already.
Okay. All right.
The judge did indicate in his temporary restraining order that if he heard evidence of continued violations, he would reinstate the order he had just temporarily rescinded. We haven't heard anything about that.
Okay.
But in our view, the best way to address this case at this point is to move forward swiftly with the hearing, which, as I say, is scheduled to begin on October 6th, and hopefully get the matter to the board, assuming there are, whether the charges are sustained or not, get the matter to the board as soon as possible.
Okay. Thank you, Gary.
Chairman Bradley, any questions?
Yeah, I have two questions. So Gary, they're litigating the fact that they didn't get a hearing yet. They still have not asked for a hearing yet. Not only have they not asked for a hearing, but when we scheduled one, they adjourned it.
That's right.
And then the next question I have is, am I wrong when you say that their corporation was dissolved actually it sounds like more than 20 years ago? The court reopened a licensed premise where the licensee technically doesn't exist?
That's also correct. I'm not sure, to be fair, I'm not sure to what extent that issue was flagged for the judge before he ruled. I know it has been in our papers, but I don't recall precisely what record that the court that granted the temporary order, what record he was ruling on.
And under that scenario, then not only would they not exist as far as we're concerned, but they would not exist as far as any state agency is concerned, correct? Meaning workman's comp, tax, anybody.
Yeah, I'm not sure I know all of the rules that apply in those circumstances, but I wonder how they've managed to get I know how they managed to get this far with us, because it is not our general practice to investigate every renewal application to make sure that the entities still exist. We take their representation in the renewal and rely on the law and their requirement to notify us of a change in circumstances. They've been charged with violations of that law, as well as with making false material statements. With respect to the other agencies, I was just going to say, with respect to other agencies, go ahead. I'm sorry.
Well, on our renewal, they must affirm that the stuff they put on the renewal is accurate, correct?
They do.
Yeah. Okay. All right. I have nothing else. Thanks.
All right, with that, I'll call for the vote of the members. First, Commissioner Fan.
I vote to rescind the summary suspension order in this matter.
Commissioner Ford.
Based on the case as presented by counsel, I vote to rescind as well.
And Chairman Bradley.
I vote to rescind the summary suspension to end the litigation and then to move as quickly as possible to hearing.
All right, with that, Chairman Bradley, I have no other items. Do you have anything else you want to bring up at the meeting?
No, I have nothing else. Thanks for getting all this together on Saturday. And Tom, congratulations. How's it feel? Father of the bride.
He's been in the family for 7 years now, so, you know, other than Katie having a different last name, everything is good. But thank you. All right, this meeting is concluded.
Thank you.
See you guys.